great. It's been a long time since I did my master's degree here, and I think as an alumni here, I'm going to have to write a letter complaining about the lack of parking on campus. I had a very difficult time finding a parking spot, and then I got lost. But I'm here and glad to be here. The presentation I want to give today is going to be pretty much a shortened version of the lecture that I give every year at SFU to a group of environmental management master's students. And so it is a bit of a whirlwind tour of Aboriginal law history in Canada and even starting back in Britain at the time when Canada was being colonized by Britain. But I really want to focus on a legal concept that's very, very important, certainly in the resource development context in particular, so the Northern Gateway Project, Kinder Morgan Project, and that is the duty to consult, the government's legal duty to consult, and how that is kind of premised on the broader concepts of Aboriginal law, but also what's required for the government to meet that constitutional duty to consult. I prefer having dialogue as opposed to just standing here lecturing. I know we don't have a lot of time. I don't know if there's time for questions as I go along. Is there, Elizabeth, do you think? Or?
Yeah, I should have mentioned. So our normal slot is till 1:30 today. For those of you who are able to stay, we do have a room booked to 1:50. So we're going to have kind of a formal part until 1:30, and then anyone who wants to stay and continue the conversation, that's great. However you want to do it with questions.
Okay.
Right?
Sure. So far away, as I'm going along, I find it much more interesting for all involved, including me, if we do it that way. But we can also have questions at the end as well, whatever people prefer. So the quote that I have here is a quote from a very well-known Aboriginal law lawyer, Thomas Berger. He really was one of the pioneers of Aboriginal law in Canada and certainly in British Columbia. And he was actually the author of, the commissioner for the Berger inquiry into the Mackenzie gas pipeline proposed project many, many years ago. And he wrote a foreword to a book about the Nisga'a people and kind of the history of the Nisga'a Treaty. And I think summed it up very eloquently and very accurately by just saying that Aboriginal rights are simply the rights to which Native people are entitled because they are the original peoples of Canada. And really, in a nutshell, that is what Aboriginal law is about. And the concepts that form Aboriginal law in Canada really stem from that fundamental principle. And I think that that principle often gets forgotten. Governments and companies, people wanting to do business in Canada, I think often forget that fundamental reality in our country. So, as I said, this is going to be a whirlwind history of Aboriginal law, and we're going to start way back in 1763. And that was the Royal Proclamation of 1763. Really, really important document. And I think some people are amazed that a document that old can still be a fundamentally important piece of a legal case today. But it very much is. It's the foundation of all of the rights that we recognize here in Canada for the Indigenous peoples. Because that proclamation implicitly recognized that there were Aboriginal interests in land, akin to common, fee simple type private property concepts. And that proclamation also attempted to protect those interests and use of lands of the Aboriginal people through the requirements of that document. So I would say this is probably, well, certainly one of the most fundamentally important historical documents in the legal context of Aboriginal law. So what this document did really is codify British policy towards Aboriginal peoples in the British colonies. And it recognized that Aboriginal people owned the lands that they were occupying and using until they entered into a formal treaty with the British Crown. And so that necessary step of entering into a treaty and surrendering their interest in land was considered by Britain at the time to be absolutely critically important before lands could be settled in the colonies. It also attempted, it's pretty paternalistic, but it also attempted to protect Aboriginal interests in land by requiring Aboriginal people to surrender their interests first to the Crown. So they couldn't just surrender their interest to a settler coming by or the Hudson's Bay Company, for example. There was supposed to be a surrender to the Crown. And that was, as I said, paternalistic. It was supposed to protect them from being taken advantage of by unscrupulous settlers or traders. And that surrender requirement, that requirement of lands to be surrendered to the Crown first, remains a part of Canadian Aboriginal law today. And so that, given how important it is not surprising that the Royal Proclamation has been mentioned in many, many of the cases dealing with Aboriginal law. One of those cases was a tax dispute, Mitchell and the Minister of National Revenue. And the court there talked about what does it mean? What did the Royal Proclamation really mean? And what the court said was that Aboriginal interests and customary law, so a recognition of self-government rights as well, coming out of the Royal Proclamation, are presumed to survive the assertion of sovereignty by the British Crown unless those interests or laws are incompatible with the Crown's assertion of sovereignty. So it has to be incompatible. One law has to say X, the other has to say Y. Or they're surrendered voluntarily, and typically that was done through a treaty, or the government extinguished them. And the courts have been clear that it can't be an implied extinguishment. Government has to be very explicit in extinguishing the Aboriginal interests in lands or their self-government rights. And I would say now, and I'm going to talk about this more, under Section 35 of the Constitution Act, which was enacted in 1982, it would be basically impossible for the government to extinguish Aboriginal interests. And there's really, I've yet to see actually any example of where the Crown showed a clear and plain intention to extinguish Aboriginal interests. They weren't thinking of it that way. The court's kind of come up with this concept after the fact, and so governments weren't conscious of that need to be very explicit. So I think that some of these concepts came as a surprise to government in Canada, because it really does give a lot of teeth to the Aboriginal interest in land and as well as their self-government rights. So I'm going to jump ahead about 100 years now in this quick tour. A very important case, again, it gets cited often, even in modern day cases, and that was the St. Catharines milling case. This was a case from Ontario. It went all the way up to the Privy Council, which is in England, which was the highest court of the land at that point in time. Supreme Court Canada wasn't the highest court. And Aboriginal peoples weren't actually even a party to the litigation. It was a fight between Ontario and Canada over who had jurisdiction to issue cutting permits for forestry activities on the land. And the First Nation had surrendered their interest in the lands that were going to be subject to the forestry operations. And so Ontario said, well, since there's no Aboriginal interest in the lands anymore, it can't be federal jurisdiction, it must be provincial jurisdiction. The court, Privy Council, ultimately agreed with Ontario, said yes, Ontario has the ability to grant the cutting permits, not Canada. But in getting to that conclusion, the Privy Council endorsed this concept of Aboriginal title and basically recognized that there was such a thing as Aboriginal interest in land that survived, but in this particular case, it had been surrendered pursuant to treaty. So really, really important case, recognizing this concept of Aboriginal title at a very early time in our history as a country. So as I mentioned, this Royal Proclamation does require that treaties be entered into first before lands are settled. And for large parts of the country, a treaty-making process was entered into. There's a number of treaties on the East Coast. There's a number of what are called numbered treaties, numbers 1 through 11, in Ontario West, as far as northeastern British Columbia, and up into Northwest Territories. A few, very few, treaties in British Columbia on Vancouver Island, known as the Douglas Treaties. And for large sections of British Columbia, by far the majority of the land base in British Columbia, absolutely no treaties were ever entered into. And so as a lawyer in this field, it didn't take me long to notice that there were a lot more cases coming out of British Columbia than any other jurisdiction in Canada. And one of the reasons that's the case is that there were no treaties, for the most part, entered into in British Columbia. So following our own laws, following the British colonial laws, following the Royal Proclamation, Aboriginal peoples in BC had legitimate cause for concern and complaint because Britain's own laws, Canada's own laws, weren't complied with in British Columbia. There was a factor with the Hudson's Bay Company, who later became Governor Douglas, who did enter into some of these treaties on Vancouver Island that are known as the Douglas Treaties, but he ran out of money. And so he wrote back to Britain and said, look, I'm trying to enter into treaties like I'm supposed to under the Royal Proclamation, but I need more money to finish this process. And Britain wrote back and said, sorry, that's a colony problem. We're not going to provide funding, so you've got to come up with your own funding to do this. And the treaty process basically came to a screeching halt, and a new governor came in and really wasn't interested in trying to reach treaties. And so instead, they took a different approach in British Columbia, where they passed legislation allowing settlers to preempt Aboriginal interests in land, and essentially, really, stole the lands from the Aboriginal people without them ever being surrendered. And so that's the historical context of why we have so many issues still outstanding in British Columbia in particular with respect to Aboriginal title and rights. I often hear, usually at a party or social setting, about these issues are all new. These issues, Aboriginal people just came up with these issues in the last 20 years to cause problems for resource development. Absolutely not true. The Royal Proclamation required treaty making, recognized Aboriginal interests, 1763. We've got a court case at the highest court in Canada recognizing it in the late 1800s. And Aboriginal people, and with a focus on BC now, were raising these concerns. They have historically raised these concerns. These are not things that they've just dreamt up, or lawyers like me have dreamt up in the last 20 years. They had trips to Britain, they had trips to Victoria, the famous canoe journey of Niska to Victoria. They've demanded to enter into treaties. They knew First Nations to the east had treaties, and so First Nations in British Columbia were really pushing hard to get treaties here as well. They formed special political bodies like the Allied Tribes of British Columbia to advance the claims to try to get treaties entered into. And then in 1992, the BC Treaty Commission was established in British Columbia. But if I had more time, I'd go into a little bit more history around that. But in British Columbia, there really was no political will to enter into treaties in the last 50 years, because the British Columbia government took the position that it was a federal responsibility to enter into treaties and not a provincial one. So the province wouldn't come to the table. But a couple years before 1992, Premier Bennett at the time changed the position of the province on that and recognized that there was a need for the province to be at the table at treaty to try to negotiate these treaties. The reality is BC controls, under its jurisdiction under the Constitution, most of the permitting and authorization powers in BC. If somebody wants a mine, if they want to cut down trees, if they want to have a hydroelectric project, et cetera, it's British Columbia that grants the authorizations. The Crown land in British Columbia is by far provincial Crown land, not federal Crown land. So it was really important that BC be at the table. And so that was important, very important moment in history when BC said they'd enter into treaties. Hasn't been a huge success story, though, since 1992. The Niska Treaty was signed after that, but it didn't actually start as part of the BC Treaty Commission process. We have the Malnath and Tsawwassen treaties, and some other treaties getting close to final stage, but considering how long the Commission has been around, I think many people feel the treaty process has not been a success. Why has it not been a success? I think it's partly lack of political will to get the provincial or federal government to get mandates or to get consistent mandates. For example, the federal government currently has no mandate to deal with fisheries in treaties. So everybody who's at the table trying to negotiate treaties right now, they have to leave the fisheries chapter undone at this point in time. And given how important fisheries are to BC First Nations, that's a huge stumbling block in a treaty negotiation. That's just one example. There was a lot of flip-flopping of mandates. I think we've got two polar opposite views of what treaties should look like. First Nations on one side, government on the other. And so trying to get them to a common place is it's a huge feat. And, you know, treaties today are not like the treaties in 1876, where it was basically a two-page document with a surrender clause, yearly $5 annuities. That's what people get, $5 a year, no indexation. They still get $5 a day today under treaties, under the historical treaties. Very simple documents. Today, they're, you know, massive documents. All the jurisdiction issues have to be worked out. It's a massive undertaking. So I think it's a combination of factors.
Sorry, can I follow up on that?
Sure.
You mentioned land, and my understanding from talking to all my First Nation friends is that the treatment of land and boundaries of land are different to the legal systems
Yes.
represented.
Yes, very true. So Aboriginal people have to fit their customary laws and their interest in lands into our common law legal system, and it doesn't fit perfectly. It's like a round peg in a square hole. No. Well, there's places where the courts have tried to make it fit, but it's an exercise of trying to make something fit that doesn't really fit. So that, I think that's part of the coming to the table with different perspectives, right? If Aboriginal people view title to land or ownership of land in a completely different way than governments do, then you're kind of starting at a place where it becomes very difficult to reach an agreement on how you go forward together. You know, the lines on the maps that First Nations have to draw, they didn't draw lines on maps, right? I mean, that's a foreign concept to them. But because they have to draw lines on maps, guess what? Some First Nations are drawing their lines here, and other First Nations are drawing it over, so there's overlapping areas now. It just creates all sorts of problems and issues trying to fit that peg into the hole. So lots of I would say legal problems, philosophical problems, conceptual problems, just problems all over the place, and a shortage of solutions sometimes. Not to say that it can't be done, but it is a huge task. Another really important milestone in the history of Aboriginal law, jumping ahead again for a few years, is 1973 with the Calder decision. And the Calder decision really was the basis for the Niska Treaty ultimately to be signed, because Mr. Calder brought forward basically an Aboriginal title claim at that time, and the Supreme Court of Canada made it clear that there is such a thing as Aboriginal title in Canada. And the quote on the screen is what the court said about that. They were there, organized in societies and occupying their lands as their forefathers had done for centuries. That's what Indian title means. Unfortunately, and this is one of the perverse things in our legal system, is there was a legal technicality with respect to how the claim was filed. And as a result, the Supreme Court of Canada could not make a finding of title. There's a technicality. They sent it back to trial. So there was no finding, like there was more recently in the Chilcotin case, of Aboriginal title in that case, but it was a wake-up call to everyone to say, whoa, okay, there is Aboriginal title here in BC. We've got to get our heads around this. And as I said, ultimately, it was the basis for the Niska to get a treaty with Canada and BC in the 1990s. Absolutely, without a doubt, the most important milestone, certainly in recent times, I'm not sure, I would say it's probably even more important than the Royal Proclamation, although that's probably a debate, is the fact that Aboriginal rights were protected in 1982 in Section 35 of the Constitution Act, when our Constitution was repatriated. There was much debate at the time about this little clause. The premiers in the West, Bennett and Lougheed, did not want to have any protection of Aboriginal rights or treaty rights in the Constitution. They came to a 2 a.m. kind of agreement amongst all the premiers on this particular language, and as a result, it ended up in our Constitution. The premiers from the West thought that the fact that the word existing Aboriginal and treaty rights gave them some protection, because they thought that by having existing in there, it would mean that whatever Aboriginal rights are, whatever treaty rights are, it's in a box. And we know exactly what's in that box right now. It's basically just what governments have said before, what courts have said before. The box is full, no more room for anything else, so we'll have certainty. We know exactly what we're getting, and it's not that big of a deal, because really the treaties don't give that much to First Nations. But since Section 35 has been enacted, it's very, very clear. It was not a full box in 1982. It was basically an empty box in 1982, and the courts have been filling it ever since. So the fact that existing was in there really has not made any difference at all. But I'm glad, I have to say, that Premiers Bennett and Lougheed at the time thought it would make a difference, because I don't think they would have agreed otherwise. They were against initially it being there at all. They did not want protection of Aboriginal or treaty rights in the Constitution. This was a compromise that was put forward in the middle of the night, and they agreed to it, thinking that the word existing, would make it less of a big deal. But that's proved to be not the case. So why do I say this is the most important milestone? The Constitution of Canada is the supreme law of our country. Every single law that governments pass has to be consistent with our Constitution, not just Section 35, but every part of our Constitution, the Charter, the division of powers between provincial and federal governments. It's the supreme law. It has to be respected. No government can just ignore the Constitution. And so by having Section 35 in the Constitution, it means that in some cases, yes, Aboriginal rights, treaty rights, can trump government's ability to pass laws or to approve projects. Absolutely powerful, powerful tool. And I would say that the enactment of Section 35 has definitely given First Nations in Canada a vehicle to bring forward their issues and get resolution in the courts, and hopefully through negotiations as well, where there's the political will to do that. Without this section, I don't even know if there would be a field of Aboriginal law in Canada, frankly. So what does it mean? I hate to say this, since it's 1982, it's been around since 1982. There's still not a lot of clarity around what Section 35 means. There's not a lot of really definitive court decisions saying this is exactly what Section 35 means. These are the rights that Aboriginal people have. This is how you can deal with those rights. These are kind of the limits. All case by case, depends on the circumstances, depends on how strong the First Nations rights are and the proof that they can bring forward of their rights and title. But what we do know, the courts have been very clear about, is that it's a measure of, the court said here, of control over government conduct. It's a check on legislative power. So again, because it's part of the Constitution, governments' laws and any authorizations or licenses that they issue must be consistent with Section 35. So it's not a veto on the part of First Nations. It doesn't mean that First Nations rights will always trump federal or provincial government's decisions, but in some cases they might, and the government better be considering how their actions are going to affect the First Nations before they take action. Otherwise, it could be set aside on that basis. So really, really important. And I'm not going to spend a lot of time on this, on the tests. They fascinate people like me who are lawyers who have to worry about getting the evidence to prove the elements. But the courts have been delineating what a First Nation has to do to prove Aboriginal rights. So there's guidance on what the basic test is for proving Aboriginal rights. So they have to show that they exercise the Aboriginal rights, such as fishing salmon, or hunting moose, or gathering medicines, that they practice that at the time of contact with non-Aboriginal society, and that it was integral to their distinctive cultures. Somewhat difficult test to meet because there's not a ton of written evidence available from the time of contact in some places in the country. And oral history evidence, although the courts have said we must take into account oral history evidence, judges are not accustomed to dealing with oral history type of evidence. Our non-Aboriginal society is very suspicious of something if it's not written down, and we worry that if people are just telling a story over the years, that it will get mistold, and that it will be exaggerated or become full of errors over time. Aboriginal cultures have methodologies to ensure oral history is preserved intact. There's certain protocols. Only certain people are allowed to pass the stories or to hold certain stories. But our system still has a hard time with the concept. So it is challenging to prove certain things were happening at the time of contact. But it has happened. There's been a couple of fishing cases in particular where the First Nations have proven Aboriginal rights. Aboriginal title is a different test. They have to, and again, this is an example of trying to fit the square peg in the round peg in the square hole, whichever way I said it, because what the courts have been trying to do is make the test work from a common law perspective of what it means to have an interest in land. So they've used a lot of really old property law principles and then tried to make it work in the context of Aboriginal title. Yes. Yes. They should. The court should, but not. They don't really. And it does raise a very concerning and legitimate point, because you take children away from their homes at a young age and you divorce them from their culture and their family life, where they're going to learn from the elders. They come back, they can't even speak their language. There is going to be a discontinuity in that transmission of information and knowledge. There's no question residential school has had a huge, huge, huge negative impact on cultures in Canada and on socioeconomic conditions and many, many things. But I'm always surprised how there's always elders in the community that still hold the knowledge. And there's always, in my experience with the different nations I've worked with, younger people who are very interested in learning that and having it passed on to them. So it has been preserved to a large extent, amazingly. And I think it just goes to the tenacity of Indigenous peoples to preserve their culture at all costs. Yes.
So, one thing I noticed in this test is it kind of treats Aboriginal culture as frozen in time,
Mm-hmm.
quite far away.
Mm-hmm.
So, have there been any issues raised with more recent cultural developments and trying to connect those? Or
Yeah, very good point. In fact, lawyers argued that very issue about the frozen in time problem. The courts have said they're not frozen in time, that they need to be able to evolve. So if an Aboriginal person used snowshoes in 1600 to go harvest, and they're using a snowmobile today, that's still a right, an Aboriginal right that's protected. Where it gets, I think, a little skewed, though, is that what is integral to distinctive society test. And things like, I want to eat salmon because I need to eat as a human to survive, is that enough? And on this test, no. I'd have to show that salmon are particularly important to me, to my culture. And so it is a bit artificial. Like I think the court was putting artificial constraints around what the rights were. If Aboriginal peoples were here in the country, surviving and doing whatever they had to do to survive and having, not just surviving, but creating these amazing cultures and societies, why do they have to show every little piece was integral to who they were as an Indigenous society? So there are issues with respect to that kind of problem and it's kind of a frozen in time problem, because maybe salmon's probably not a good example, but certainly there's certain species that they would have harvested at that time that they may not be harvesting today. Maybe because non-Aboriginal harvesting has destroyed the resource. Does that mean they can't have a replacement resource? It just gets a little murky as to where the lines get drawn. Yes? So the case actually is the Vanderpeet case, where the Supreme Court of Canada, and there's been other cases talking about it, but I think Vanderpeet was the first time the Supreme Court of Canada discussed it. The trial judge in that case, I think the same thing occurred in the Delgamuukw title case too. The oral history evidence really wasn't given weight by the trial judge, so the court below when the case first started and the judge heard all the evidence. didn't give the same weight to the oral history evidence and kind of just, poo-pooed the oral history evidence. And the Supreme Court of Canada gave a lot of guidance around that to say, no, oral history evidence is just as important as the Western written evidence. But the First Nation has to be able to show that there was some process for keeping the knowledge, right? So that it can't just be Joe Blow standing up and passing a story. Certainly if I were putting together a case that depended heavily on oral history, I would want people who knew the rules around how you maintain oral history. Think of one client who is our client in the Northern Gateway process. They have very strict protocols of who holds what stories, who can tell what stories. You can ask permission from the person, but it's handed down generation to generation to specific people. And so you'd want to show that so that it's basically like the equivalent of showing that your article that you're relying on as evidence is in a peer-reviewed journal. It's the same kind of idea, that it's somehow peer-reviewed, somehow legitimized because of the processes in place in that community. But in some communities, because of all the disruptions, that can become tricky. Yep, absolutely. First Nations are wise to videotape elders, to collect the evidence, make sure that they're collecting information in ways that can be justified later, right, to show that this was legitimate. Problem is everything costs a lot of money, right? Collecting information and doing it in the proper way that's going to be acceptable in the court of law is expensive. So that's a real problem, I would say, for many First Nations. And they've got so many issues they're dealing with. I mean, putting aside all of the problems with residential schools, many First Nations have so many massive projects being proposed in their territories. Not even massive, but we certainly do a lot of work where massive projects are proposed because we do a ton of work in the oil sands for First Nations. And they just don't have time to be proactive. They are so reactive to everything that's being proposed in their territory. And really, I would say, spending their resources to protect their lands and resources and their rights. It's not like there's a big pot of gold at the end of the rainbow for them when they advance their rights. They're doing it as a shield to protect their interests and their lands and the caribou, for example. But absolutely, that's an important thing to do. So as I said, the test for title is somewhat different, and the court was trying to make it work from a common law, property law perspective. But again, there's problems when you try to translate this, if you're the person that has to prove it, because you've got to show at the time of sovereignty, so not the time of contact, it's a later date. It's when Britain first asserted sovereignty over Canada. You have to show that you occupied those lands and that you had exclusive occupation, which meant that you tried to keep others out. So I've seen cases where evidence has been led of big war canoes coming out from the land and surrounding the explorer's ship, for example. That's evidence of exclusive occupation, right, that they're trying to keep others out. So there is evidence that can be collected. Because it's later in history, at the time of sovereignty, there is more written evidence around that. There's journals that were kept by people on various ships in the area. There's Hudson's Bay Company records, a lot more Western evidence of who was where and who was exercising their rights where. But still, huge challenge. And this kind of case is probably a 15, 20-year case and would cost in the millions for First Nation to bring forward, because you're going to be probably going all the way to the Supreme Court of Canada, the appeals all the way. You're probably looking at a trial that's well over a year long, so all of that time in court. You're going to have numerous experts, anthropologists, historians, ethno-historians, I've even seen botanists, just archaeologists, archaeological work. Just so much has to go into a title case that even with the recent great decision in Chilcotin, we're not going to see a whole bunch of title cases being brought forward and adjudicated all the way to the Supreme Court of Canada, I don't think, anytime soon. But, you know, and this is certainly important in the Chilcotin case, if title's shown, then it comes with some real teeth, because it does mean exclusive use and occupation of lands, and it does mean the right to choose what lands can be used for. And there's also an economic component to it. So it's not just a bare declaration, yes, you have title. It actually means something. It means that the First Nations have the voice over what happens to the lands, except that there's a concept called infringement. And this is where I get back to Section 35 is not a blanket protection or trumping of government laws or actions. So the courts have created this concept of justified infringement. So an infringement occurs whenever a right, an Aboriginal right or a treaty right, government does something that is inconsistent with that right or infringes that right, impacts that right. And the onus is on the First Nation to show how this particular law or this approval of the Northern Gateway Pipeline project infringes their rights. That's not the end of it, though. So let's say they go through all of that evidence, they prove they had the rights, they prove that there was an infringement by government authorization of a project, then the onus goes to government to prove that the infringement was justified. And that's where the balancing comes in. Because if government can show there's a valid legislative objective and that government consulted with the First Nation and basically tried to address the concerns, then the courts can find that the infringement is justified. In other words, legal. So, Chilcotin, Aboriginal title. We know they have Aboriginal title to the tract of land the Supreme Court of Canada recently found, but that doesn't mean that the government of BC can't still issue cutting permits in that territory. Even though title comes with the exclusive right to use and occupy, the exclusive right to decide how the lands would be used. If government can show that there's a valid legislative objective in issuing a cutting permit on Chilcotin lands, and that they consulted adequately with the First Nation, the Chilcotin nations, conceivably, that might be okay. That might be legal. Yes? So that's another example of where the courts are still working it through. Conservation has been identified for sure in a case, a sparrow case, and some other cases dealing with fishing rights. So if there's a particular species that's going extinct, it could happen in the context of caribou, for example, and government passes a law saying nobody can hunt caribou, that would probably constitute justified infringement because it's to prevent the caribou from being overhunted and going extinct. There is language in the Delgamuukw case, which is another Aboriginal title case from several years ago, where the court also talked about economic interests. And in the Northern Gateway legal proceedings, assuming we get leave from the Federal Court of Appeal, that's going to be a key issue. Do economic interests of all Canadians in a broad sense justify infringements of Aboriginal title or Aboriginal rights? And frankly, it will depend who is deciding the case, how that question is answered, because there's as much politics as law involved in that answer. So yeah, lots of unknowns around that still. Elizabeth, how long do I have before we have to break? Did you say till 1:30?
We've got about 15 minutes.
Okay.
Do many people stay a little bit longer? Yeah. So,
Okay.
in 15 minutes, technically some people might have other questions.
Okay.
We can go for another 10 minutes.
Yeah, and people just feel free to leave when you have to. I'm just going to skip over a few slides, though. So there is on that question, I don't know if people get copies of the slides, but on that question, there's a few slides in here talking about kind of what the requirements are of justification that the courts have said. It's all pretty general, pretty conceptual in nature, but it gives you a sense of kind of the things that the courts were considering being a justified infringement. But what is really important and what I really want to focus on in the last little bit. Pardon? Yep, let me just go back and. I'm not, actually, because I was wanting to focus more on consultation.
Okay, so but what consultation now means, as I understand, when you have Aboriginal title and you go back to it requires consent. The government can still infringe if you suggest it, or it can justify it somehow as an interest and use the term fiduciary
Right,
interest and fiduciary responsibility.
right.
So my question about
Yes.
can the government ever tell an Aboriginal group that its fiduciary responsibility is different from how an Aboriginal group would deal with something smaller?
Yeah.
So if
Yeah.
information for different reasons, they need consent, could a government rule?
Right. So, and I've heard this a lot touted around in articles, that the law is now that you have to have consent. That's not true, and I think you made that clear. There's two scenarios now for Chilcotin. They've got proven title. They can consent to a cutting permit, for example, but government can still justifiably infringe, and that would not require consent. Yes, with fiduciary. Right. So that's actually not that new, because even in these old cases, the courts always have talked about the need for the Crown to act in accordance with the honor of the Crown and its fiduciary relationship with First Nations. I think what is interesting in that Chilcotin decision, though, is the way, and I didn't bring it actually because I'd pull out the excerpts, but the way that the court has framed those questions, that getting back to your question about what's considered to be a justified infringement, the way that they've framed how the government has to be looking at whether something's justified or not, and they have to be considering their fiduciary relationship with that First Nation, and they have to consider the Aboriginal perspective and not just kind of the national interest. So we're going to see this come out for sure in the Northern Gateway litigation, for sure, that this need, that you can't just look at it through what's in the best interest of all Canadians. You have to consider, when you're looking at the public interest, what's the First Nations perspective on that, and how is it affecting that First Nation, and how is that consistent with the fiduciary relationship between the Crown and that First Nation. If we're going to go in and destroy an entire watershed that's critically important for that First Nation, they have title there, they harvest there, there's culturally important areas, there's sacred sites, we're going to go do that, surely it's got to be more than just, wow, there's a lot of money to be made from this project, and so therefore it's in the interest of all Canadians. But we don't know exactly how those principles are going to play out yet. But you're right, they pushed the bar on that higher. Yes. There is supposed to be proportionality. So how that plays out, again, there's so many unknowns, so many questions in this area of law. But there is supposed to be some proportionality between the legislative objective and the impact or infringement that's going to result to the First Nation. Yes, or rights, proven Aboriginal rights. So title is kind of the all highest end of Aboriginal rights because you own it, right? You own and occupy it. But there's a whole host of, I'll call them lesser rights. That's probably not a fair way of characterizing it, but the right to hunt, the right to fish, self-government rights, which actually isn't a lesser right at all. It's actually a really key part of having title. You also want to have self-government rights. So there's all these other Aboriginal rights, and you don't have to prove exclusive use and occupation to prove you have a right to harvest salmon, for example. And if government did something that adversely affected the right to harvest salmon, then they would have to justify that infringement as well. And the tests are basically the same for justification either way. So the whole concept of consultation has become really what I would say the driving force in Aboriginal law in the last 15 years. And it comes from these infringement cases. With Chilcotin now, because I think the bar is higher, we may find consultation becomes less of a tool, and we go back to proving rights and infringements, unjustified infringements. But what the court said when when a government is trying to justify an infringement, they have to show that they consulted with the First Nation. And that came out in the Sparrow case. It was a case involving a man with musqueam, a harvester, a fisher. He was out fishing. His net was too long under the regulations, under the Fisheries Act, and he was charged with fishing with the wrong size of net. And he defended the charge on the basis that he had an Aboriginal right to fish. He was never consulted, his nation was never consulted about the net length regulations, and as a result it was an infringement. And so the court accepted all of those concepts. It was the first case under 1982, under Section 35 after 1982. So this idea of consultation really has its genesis in these early infringement cases. But consultation is another one of those legal concepts in this area of the law that is not clearly defined. And what's required to meet the duty to consult really depends on the circumstances of the case. The court talked about the fundamental importance of sharing information and talking to the First Nation. That has to happen. Otherwise, the government is not going to be able to meet the justification test. And in some cases, it goes so far as accommodation. So in those cases where the impacts are going to be large and the rights at issue are strong rights, then the government may actually have to do something to accommodate. For example, if there's a road that's going to be built, maybe they have to say no. That rarely happens, but it is an option for government. But maybe they have to move the road at least to miss an important hunting area, for example. That would be a form of accommodation. Economic benefits, so revenue sharing like we see happening in the mining sector in BC, that's a form of accommodation. It's a recognition of impact and some kind of compensation for that. And all of this is part of the broader objective, which the courts have emphasized time and time again, of reconciliation. So it's not a trumping of one over the other. It's supposed to be trying to achieve some reconciliation of the fact that when non-Aboriginal people came to this country, Aboriginal people were here using their lands and the resources. And we've just got to get our heads around that and figure out how we're going to make that work. That's the message the courts have been telling everyone, governments and First Nations. I'm not really going to go through all of this history of consultation. I find it just really interesting to see from a legal perspective how it's evolved over time. But as I said, what we do know about it is that it's supposed to be in good faith with the intention of substantially addressing the concerns of Aboriginal peoples whose lands or resources are at issue. So it's not supposed to just be government coming and talking to a First Nation and saying, look, we're thinking of improving the Northern Gateway Pipeline project. What do you think about that? Oh, you got concerns about that? Okay, we'll write those down and we'll go back and Cabinet will make the decision that they're always going to make without any attempt to try to address the concerns. And am I oversimplifying it? Yes. But at most consultation meetings that I've been to, the government isn't really there with a mindset of trying to address the concerns. They're there to paper what's been said and to basically say that they met and talked about the project with the First Nation. Time will tell whether that's enough. I do want to spend a little bit of time, though, on this duty to consult before the nation has proved title or Aboriginal rights. So all of those other cases I've talked about up until this slide have dealt with a case where the First Nation has proven they have rights or title, and the question then becomes, is the government action an unjustified infringement? And in that context, the court said factors are whether there was consultation. The big debate after those cases came down, and it arose here in BC, was, okay, well, if the First Nation hasn't actually proven they have rights yet, or title, then there should be no duty to consult, because the court's talking about that in the context of proven rights infringements. And First Nations said, wait a minute, that can't be right, because some of us are at the treaty table with you, government, and we've picked out certain lands that we want to be our treaty settlement lands. And if you don't have to consult with us, then while we're sitting here at the treaty table, you could be issuing cutting permits and mining permits, and the land could be completely denuded of all resources before we ever sign off on the treaty. So surely you must have to consult with us beforehand. Government really dug in their heels. No, 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 no duty to consult, no duty to consult. And it went all the way up to the Supreme Court of Canada. On its way there at the BC Court of Appeal, found that, yes, there is a duty to consult even before the First Nation proves their rights or title, and found even that the company in that case, which was Weyerhaeuser, had a duty to consult. So it was like the sky is falling for governments at that point, and for Weyerhaeuser too. So they went to the Supreme Court of Canada, and the Supreme Court of Canada upheld the lower court with respect to government's duty. So they said, yes, doesn't matter if the First Nations proven their rights or not. If you're doing something that could, just could, is enough, potentially adversely affect the First Nation, you have to consult with the nation. And it doesn't matter that they haven't proved their rights yet. They did say, however, though, companies like Weyerhaeuser, other proponents, do not have the duty to consult. It's a Crown or government obligation only. Hugely, hugely, hugely important case, because now every single project that's proposed in this country, the government has a duty to consult with First Nations. And to the extent that they don't consult with First Nations adequately, or at all in some cases, there is a lawsuit ready to be brought by the First Nation to challenge the approval. I just have a question here and then one here. Yes. Yes, it does. That's the downside of requiring nations to start drawing lines on maps, I would say. So if there's overlapping claims, then the government must consult with all of those First Nations. Now, the test is, let me just pull it up here. Next one. The duty, the scope of the duty depends on two things. How strong is the rights claim or the title claim being advanced? And secondly, how big is the impact? So if you've got two nations both claiming the same area, one's got a really strong title claim, let's say Haida, to the coastal area of Haida Gwaii, and some other nation suddenly said, we assert territory there too. The government could look at that and say, well, Haida have a really, really strong claim. This other nation is not so strong, and so the duty to consult wouldn't be as deep for that second nation. But if they get it wrong, then they can be held to task for that by the courts. I think there was a question here, and no? No? Okay. Question here? Yeah. Yes, very good question, and that is a reality. Especially in some places like Alberta, the proponents do all of the consultation. Government doesn't really do any consultation. So what the court said in Haida is that it's a Crown duty, it's a government duty. Proponents don't have the duty, but government can delegate procedural elements of consultation to proponents. Another example of we don't really know what procedural elements of consultation means. The courts haven't really clearly defined what that means. I think in practice what it means is in Alberta, all of the engagement happens between the company and the First Nation. In BC, if there's an environmental assessment process, a lot of the engagement is delegated to the proponent, and so the proponent's the one that's meeting for the most part with the First Nation. Where the legal bounds are of that is still unknown, but that's definitely happening, and it is legal up to an extent. Yes? What are the downsides of that? Well, I think one of the downsides for the First Nation is they never get to sit with the decision maker, right? So they never get to try to influence how the decision is made or to get that decision maker to factor in its concerns and the impacts to its rights when it's making the decision. So its information is being filtered through the proponent, and of course the proponent wants the project to go ahead, so they're not going to be a strong advocate for the First Nations' perspective on issues. I also think there's a legal risk to government. If they are really delegating everything away, then surely that has to be more than just delegating procedural elements. And I think there's, the possibility a court would overturn the approval on that basis. Yes.
Going to need information for this, and the government's responsibility.
Yes, so First Nations do increasingly seek to have engagement on climate change. But what's happening is that typically governments aren't willing to talk about it because they don't see that as an impact from the proposed project. It's a bigger problem. And one of the fascinating and disturbing things I've seen happen in the last 2 years now is that climate change has become the scapegoat for all impacts. So Site C, I was involved in that regulatory approval process, and I acted for nations in the Peace Athabasca Delta, hugely important. It's one of the largest freshwater deltas in the world. Last nesting sites for whooping crane. It's just getting pounded by oil sands, extractions, contamination, and existing regulation on the Peace River. And the position of the proponent was that the problems in the Peace Atha Delta, because it's drying up, is caused by climate change, not our projects. And I'm seeing that more and more in projects, people's blaming the problems on climate change, not our project, it's climate change generally. So it's almost perverse what's happening with climate change, and how that plays out, who knows. But it's very hard to get engagement on climate change issues, very hard to get engagement on cumulative effects, period, in any of these approval processes, because government will say, well, we're just dealing with this one little project. And cumulative effects, it's too big, we can't deal with it. But really, it is that death by 1,000 cuts that is adversely affecting First Nations across the country. It's not that one little project over there or that one there. It's, unless it's a big mine, it's all of them together. And so that's, I think the law's definitely going to be the courts are going to be wrestling with those bigger issues, I think, very soon. They're just too important to ignore. Yes? I wish. Some processes, like Northern Gateway, there was some funding provided by the Canadian Environmental Assessment Agency, and there was some funding for particular studies by the proponent. But those processes are, if you were to engage fully in that process, it was a multi-million-dollar investment. It was a hugely long process. Evidence had to be collected. So the amount of capacity funding that was provided was a drop in the bucket compared to what was needed. And that project, that was more capacity funding than I've ever seen before. So most projects have none or very little capacity funding. And so the First Nations forced to take money from other places like schools and education, housing, social programs to put it into these fights, which again, there's no money at the end of the day, at the end of the road for them. It is just a fight to protect their lands and the resources and their rights. So there is a misconception out there that First Nations, all their legal bills are paid by government or some magic fairy somewhere, and it's just not true. They're taking monies that they have from other sources and choosing to use it to protect what's important to them. Okay, so let me just fly through. There's lots I could talk about the duty to consult. There's some principles that the courts have started articulating, but again, it all depends on the particular facts of the case, and the bigger the impacts, the stronger the rights claim, the more consultation that's going to be required. But at the end of the day, it's not a veto on the part of the First Nation. The First Nation doesn't get to say, you know what, we don't want this project, just go away. That's not the power that the duty to consult gives First Nations.
What's an interpretation of duty to consult as the acceptance of event?
The acceptance of event?
Yeah, of event. Like First Nation comes and says, I'm not happy.
Right.
Okay, you say this is untenable.
Right, yes. Yeah, it's, unfortunately, I don't think that's what it's meant to do, but unfortunately I think that is how it's being operationalized. I think governments feel as long as we check off the boxes, sent referral to First Nation, called First Nation to follow up, gave First Nation opportunity to speak its mind, met with First Nation when requested to meet, sent summary of concerns to First Nation. Check, 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 check. We're done. It's very mechanical. I think this is just my own personal, everything really I've said is my personal view other than some of the legal principles. But my personal view is that governments are more interested in trying to get around the fact that there are Aboriginal rights, including title, in this country through consultation than they are trying to address the impacts to those rights through consultation. And if governments would just accept what the courts have said and get on with reconciliation, we'd be way farther ahead than we are, and we wouldn't be embroiled so much in litigation. There would still be differences of opinion. There would still be some projects where governments would say, yes, let's go ahead, and First Nations wouldn't agree and they'd be in court. But frankly, if governments did a better job of consultation, it'd be harder for First Nations to take them to court. But yeah, it's hopefully we'll get there one day, but we need the courts to be constantly shaking the stick at governments before we seem to be able to take steps forward. Yes?
In some ways, the courts and the laws decision weighted against First Nations, so there's constantly their own interpretation. The stock model is they don't have if they don't have capacity.
Right.
It's not much just
That is the one nice thing about the duty to consult, though, and that's why it has become such an important tool. Most First Nations couldn't go through an Aboriginal title case to prove where they have title, but duty to consult is a much smaller issue to deal with. It's only in relation to the particular project. You don't have to prove your rights. You want to put some evidence in to show you've got a strong case, but you don't have to worry about putting the whole gamut of evidence in. The procedure that you use to challenge a project is much shorter. It's called a judicial review application. So you go by way of affidavit evidence. You can get in and out of court within a year sometimes, whereas a title case is years and years and millions of dollars. So that duty to consult, I mean, that's part of the reason it has been so important since the Supreme Court of Canada first found that it existed, because it does provide a more pragmatic, more affordable tool for First Nations to use. The other thing that's happening with the duty to consult is that companies know there's an obligation to consult. They know there's not a lot of certainty around what's required to meet the duty. So for those First Nations who are interested in economic opportunities, and it's not every First Nation, it's not every project, but for those who are with respect to a particular project, it does give some impetus for the company to knock on the door to say, do you want to talk about an impact benefit agreement? Without the duty to consult, I don't think we'd be seeing that happening as much. So I hear what you're saying. Absolutely, it's not the perfect tool, but it certainly gives them more of a voice and more quivers, more arrows in their quiver, so to speak, to use in legal challenges. I had the Musqueam case in here, which of course was the golf course here at UBC, where the province was a failure to consult case. This was an example. Musqueam was at the treaty table trying to negotiate. The golf course were lands that they had identified as possible treaty settlement lands, and the government entered into, signed an agreement of purchase and sale before they even told Musqueam about it. And then they wanted to consult after they had decided, and the court said, no, if you're going to consult, and you have to do it before you make your final decision. So it was a timing issue, really. And they subsequently did resolve that issue. The other big battle that crept up after the Haida case was whether or not there was an obligation to consult in treaty country, so places where there were treaties. Was there a duty to consult? Government dug in their heel again, saying no duty to consult. Supreme Court of Canada said, yes, there is. So the treaty gives certain rights to First Nations who have treaties, the right to hunt, fish, trap informally on all of the surrendered lands. If government's going to approve an oil sands mine in an area where the First Nation hunts, fish, or traps, then government has to consult with that First Nation before they approve the oil sands mine. We talked about third parties already, and as I said before, obviously proponents and companies do have a reason to care about this duty to consult and Aboriginal rights, because if government messes it up and drops the consultation ball, it's the proponent's license that gets revoked. It's the court quashes the proponent's license, or that could happen in a court case. So proponents do have a vested interest in making sure that the issues are addressed and that there's proper consultation. And that's why many good proponents will engage with First Nations and enter into agreements and try to address concerns. And in my experience, I have negotiated impact benefit agreements in the past. I'm doing less of that these days because I've got too many regulatory fights to fight. But there's some great success stories out there, some real win-win scenarios where the company benefits because they get a local employment base. They don't have to fly people in from all over the place. They can use local catering companies and contractors. First Nation builds capacity. They get some economic benefit from the project that's impacting their rights. And good relationships are built between the company and the First Nation. So there's definitely some success stories and some win-wins. So to the extent that government would care what I would have to say about this, just some considerations there for government. Again, I would say if they did consultation the way that it should be done, I think it would be much harder to challenge projects. And there would be the certainty that companies and government are looking for these days. Talked about really the downside for industry already. Huge, huge downsides. You know, courts don't often set aside permits for projects, but they will often delay projects. And for many projects, delay is the same as death. Mackenzie Gas Pipeline, it was caught up in litigation over consultation issues with one of our clients. I mean, that's just one factor in many of why it didn't go ahead, but delay often will kill projects. And I'm happy to take questions after this, but I always like to end on this note because this is from the Supreme Court of Canada, from the earlier Aboriginal title case, Delgamuukw. Let us face it, we are all here to stay, which really sums up the message that I was delivering earlier about the need just to get on with reconciliation and for governments to just accept that the courts have said there are Aboriginal rights, including title, in this country, and we can't just be building projects here, there, and everywhere without addressing the impacts to those rights. So any other questions? Yes. I certainly don't buy into the theory that I've seen out there about it's just delay for the sake of delay. I certainly don't think the First Nations that I've seen involved in the process, that it's just a delay game. The concerns about the Northern Gateway project, I think it just raises questions about where does the line get drawn, about what's an acceptable project, what are acceptable risks and what aren't. And just because there's huge economic upside, and that's actually debatable, by the way, whether there is huge economic upside. Gas prices are going to go up at the pumps, and there's all sorts of other adverse effects that could result from these pipeline projects. And the number of jobs, increases in jobs, really are pretty limited just during construction phase, which is a very short period of time. But anyways, even assuming there's huge economic upsides, is that enough to put the coast at risk, to put the resources at risk, to put societies at risk? And that is the concern of the coastal First Nations, that if they can't go collect seaweed at particular places where they like and want to collect seaweed, or go shellfish harvesting for 7-8 years because of an oil spill, that is going to have a huge adverse impact on their ability to stay who they are as Aboriginal people. And they've decided that risk isn't acceptable to them. There's no question that their perception of risk is very different than the perception of risk of somebody in an office tower in Calgary, who may see the risk as, it's a small risk that will happen. But for those First Nations, the risk is unacceptable, and so they are fighting to the end to stop it. So it's not a leverage game. It's not it's not a game at all to them. It's they're fighting to protect who they are and the lands and resources in that area, and they just don't find the risks acceptable to them. Yes. Right. So in the treaties, when treaties are negotiated, there will be sections on treaty settlement lands, which will be basically the equivalent of Aboriginal title lands. And then there will be harvesting rights or Aboriginal rights. And there'll be self-government sections as well. So all of the different types of rights will be reflected in the treaty provisions. With respect to the non-treaty scenario, so if a First Nation doesn't have treaties, I've seen the Aboriginal rights used more as a shield than a sword, in the sense that people are asserting their Aboriginal rights to fish or hunt, etc., to defend against a charge under the Wildlife Act or under the Fisheries Act. So it's not that they're going to court saying, we want a declaration that we have the right to fish in this particular area. It's more, I've just been charged with illegally fishing. I have an Aboriginal right to fish, so therefore the charge can't stand. So we're not seeing that areas are being delineated geographically as to where people have rights to harvest. Yep, so they know where the areas are. The First Nations know where the areas are. They will often do what are called traditional land use studies or traditional marine use studies. And so those studies certainly aren't comprehensive collections of all data on where everybody harvests, but it's a representative sample to show, this is a key harvesting area, this is an important cultural site, this is a sacred site, this is a burial site, that type of evidence. And those documents are routinely commissioned and routinely put into consultation processes. But that's different than a court saying, here's your right, this is your area where you have a right to fish. We're not finding declarations from the court at this point because First Nations aren't really bringing it forward in that way. But in a failure to consult case, for example, and there's been many of those, so a First Nation puts evidence in that they hunt in a particular area that will be adversely affected by the project. Let's say it's moose, and there's evidence that moose will be adversely affected by the project. That evidence will go into the court, and the judge will consider that in deciding how deep the duty to consult might be. So you may get a finding from a judge saying, this First Nation hunts moose in that area. But it's not meant to be kind of a global statement of that's the only place they hunt moose. It's very project specific. Yeah. Yes. You mean like project by project, court case by court case? Mm-hmm. Yeah, really good question. On the one hand, thank God there's Aboriginal and treaty rights, because it really is the strongest tool in dealing with projects and trying to mitigate impacts from projects, because the environmental laws have been gutted so much, particularly under this government. So there aren't a lot of environmental regulatory tools left anymore. And so that's why I think for things like the Northern Gateway project, it really is the First Nations cases that are, I think, we'll see what happens, but I think they're going to determine the fate of that project. It won't be the environmental issues. What are the broader policy questions? Well, I certainly don't think it's the way to deal with environmental issues. And I would think that every Canadian would want to have a robust environmental regime. It doesn't mean people are anti-development. I'm not anti-development. Most of my clients, in fact, I can say all of my clients are not anti-development. But we need to find that right balance. And I don't think it's fair that First Nations have to bear the brunt of fighting these issues, because it's their funding from their schools or their health care or whatever that they're having to channel into this. So yeah, I'd much prefer to see the issues dealt with at a policy level appropriately. But that's certainly not the reality we live in right now, in my view. I would say, I mean, everybody has the same tools, but those who have the strongest tools are those who don't have treaties. So that's part of the reason why the British Columbia situation is somewhat unique. There are places in Quebec, a lot of places in Quebec without treaties. Far north, no treaties, although there's modern day treaties now in a lot of those areas. So it's harder with treaty rights because the rights are defined in a very, very limited way. Hunting, fishing, trapping is formally. So it's harder to use the tools in the same way there, but First Nations are using those tools. And there are some big question marks in some areas, like the oil sands. How can you hunt, fish, trap informally if you can't hunt a moose because the meat's contaminated, or the fish all have too many fins, so you don't want to feed that to your child. There's big question marks. And I would say that every First Nation has tools that they can use. I think it's just stronger in BC.
If you want to ask questions from Paul, it's okay. We have to let the next class in. This has been really informative and such a great pleasure to have you here. So thank you very much for coming.
Oh, you're welcome. Thank you.